This week, we'll be discussing DUI cases and the length of time that a DUI case takes, but also what happens to your license to start. So most people think if they refuse a blood or breath sample, for example, with the implied consent law, you automatically lose your license. Or if you're arrested even just for DUI, you automatically lose your license upon being arrested. But that's not true. Your license is fully valid whether you consent to a blood draw or refuse a blood draw for the entirety of your case while it is pending. The only exception is with the implied consent charge. It is a finding at the preliminary hearing rather than a jury trial. You can appeal that right, or if you waive the preliminary hearing, which is generally not advisable because we can file an appeal to allow you to keep your license pending the appeal. Generally, that's going to take a long period of time. You have every right to drive. There are exceptions for when you may need an ignition interlock while the case is pending, like if there was a juvenile in the vehicle, an accident, or you have a prior DUI, reckless driving, or reckless endangerment. But after that, in any event, the case is pending. You have every right to drive. What is the longest wait period, I guess, in General Sessions Court before we even get to discuss the case with the prosecutor?
Yeah, so generally the biggest hurdle in a lot of DUI cases is going to be the toxicology, the blood test. In East Tennessee, alcohol results, the way the TBI tests them, they always test for alcohol first, whether or not alcohol is suspected. It's cheaper, it's easier, it's faster. So their protocols is to examine whether or not there's alcohol first. And that's also because there's a presumption in the law of a 0.08 BAC being impairing. So that alcohol result is typically going to take anywhere from 10 to 12 weeks. In that time, there's not going to be a lot of negotiations with the prosecutor. It's going to be a lot of getting videos and formulating a strategy for the case pending that result of the alcohol. If that alcohol result comes back a 0.08 or lower, they will then send it off for a drug toxicology. Now, that drug toxicology is going to test for a lot of different drugs, and it's going to take another 10 to 12 weeks from the day that it comes back with the alcohol. So we're looking at anywhere from 20 to 24 to 26 weeks before we even have a substantive conversation with the prosecutor about resolving a case if drugs are the alleged intoxicant. Emily, I guess, can you talk to us a little bit about how waiting that long can affect negotiations with prosecutors?
Yeah, so like Dakota said, when we don't have those results yet, a lot of the prosecutors, any of the prosecutors really aren't willing to resolve that case until they have that information themselves. So that means that we have to set that case out far enough for them to get those results. Now, in General Sessions Court, that is where we set cases for what we call status dates or OTR dates. That is where the purpose is to negotiate with the prosecutor. Every county is a little different on the timelines here, where some counties will set it for a negotiation date, talk to the prosecutor, may come to a resolution on that day, but the prosecutor may indicate they want to watch the body cam footage. Maybe they'll give us a deal, or give us an offer, but want to reset it so they have an opportunity to watch the body cam footage. Sometimes we request that they do watch the body cam footage so they can see the arguments that we've asserted. And then we'll set it out for another negotiation date and then maybe come to a resolution then. Other counties just set the date for a preliminary hearing date right away. So the timeline isn't as long because we don't set the date out for the prosecutors to keep exploring the case. Now, if we don't come to an agreed resolution where there's a plea offer that you want to accept and enter into, then we set the case for what's called a preliminary hearing. That is a probable cause hearing where the state puts on the witnesses. It's usually the officer who testifies as to their observations, why they pulled you over, what observations they made to conclude that you were impaired that led to the arrest. At the end of that hearing, the judge determines whether or not they find probable cause, which 51% more likely than not is kind of what we say that standard means. If he doesn't find probable cause at the end of that hearing, the judge can then dismiss the case. If he does find that probable cause standard, then it gets bound over to the grand jury, which, do you guys want to talk about the grand jury and criminal court portion of a DUI case?
Yeah, so when your case is in the grand jury, it's strange because nothing is really happening. Now, like Brandon talked about earlier, assuming that there has not been an implied consent hearing or anything to that effect, your license is still going to be in good standing. It's just a matter of the case has to go through and be reviewed by the grand jury, which is looking for the same standard Emily was just talking about judges are looking for, which is just probable cause, right? More likely than not. So in that meantime, there's not really going to be any court dates. You may have report back or check back dates, but the state is going to have 1 year that the statute of limitations is told from the date of the probable cause hearing to indict you. Now, some places meet 3 times a year. Some places meet every month. It just depends on the county and depends on who's prosecuting it, because you may be up in circuit court, what we would call jury trial court, in 1 month. You may not be up there for 6 months. You may not. It may take longer. It just depends on how many cases are going before you in the grand jury and what all they're expecting to do with it.
Yeah, and then criminal court, like you mentioned, is really where you have jury trials. But before ever getting to a jury trial, it's where you have motion practice. So you file motions mainly off of the preliminary hearing that you have. And that's why it's so important for a DUI attorney to get involved early in the case to be able to determine what all of the legal issues are. Because generally the state's witnesses are the least prepared at the preliminary hearing than any other point in the case. We are the most prepared because we take it as seriously as a jury trial, knowing that that officer is not going to be as prepared. And so with them not being as prepared, we're able to strategically think of the questions we want to ask to set up a motion to suppress evidence. Argue they didn't have reasonable suspicion to pull you over, reasonable suspicion to request a field sobriety testing, or probable cause for an arrest, a blood sample, and for that implied consent charge. So there's a lot of motions that we're able to set up through that preliminary hearing to then argue in criminal court, or to use for negotiation purposes to get a better offer in criminal court, ideally, than the offer that we got in general sessions court, or to suppress the evidence through a motion. And then at the end of the day, if we're not able to reach a resolution, that's when we look at a jury trial. Generally, the timeline to go to a jury trial from the time of arrest through a preliminary hearing, through the grand jury, through motions, all the way to a criminal court jury trial, it's going to be generally 2 years or more. There are some motions depending on the gap in time that it takes. There may be a speedy trial issue. For example, like when Andrew mentioned the length of time that it takes to go through the grand jury. If it takes 6 or more months, might be an issue that we can argue speedy trial. There also might be issues with the statute of limitations. So Andrew mentioned staying of the statute of limitations. Well, if the case gets dismissed in general sessions court, the state can bring it through the grand jury despite a dismissal. But if it gets dismissed and they don't bring it through the grand jury until over a year later, there's an argument that they did not meet the statute of limitations, or a speedy trial issue separate from that as well. So there's a number of issues as to the length of time that a criminal court case takes, specifically with DUIs, because of the length of time the blood samples take, like Dakota talked about, that these issues really do come up a lot as far as the timeline of these cases, far more than any other misdemeanor case, because any other misdemeanor case, we're generally in court pretty quickly. We're not waiting for chemical testing and field sobriety testing and all this intricate evidence, scientific evidence. So it really is a longer time period. Usually takes closer to that year if you're having that preliminary hearing, generally at least 6 months before anything is really happening on the case.